Hello, I'm Adam Kielich, the principal attorney at the Kielich Law Firm in Bedford, Texas, where I help clients with employment law, personal injury, and family law needs. Today's short video is going to be a little different. Rather than talk about the claims or defenses or legal issues that an employee can bring when something bad has already happened, today's video is going to talk about what an employee can do right now to protect themselves in the event a claim arises somewhere down the line, whether that's a claim that's brought because the employee has been terminated or demoted, or the employee is trying to bring a claim under a benefits plan, or to ensure that they're paid for work that's already been performed. Regardless of the type of claim, many employment claims are resolved either through a settlement, an administrative process, or through litigation, which itself may conclude in some sort of settlement or mediation. But along this process, the amount of evidence and what kind of evidence that employee has on his or her side can often make the difference between how quickly the claim is resolved and what kind of relief the employee can receive. Most employees don't realize the kind of evidence that they have available to them on a regular basis to protect their job or to protect a claim in the event that something goes wrong and their employer has done something wrong to them, or they need their employer to do something correctly or to do the right thing for them. Often employees overlook collecting this evidence and overlook keeping it when they have it. And as a result, when something bad happens, then the employee is scrambling trying to find this evidence. This is a particular problem if the employee quits or is fired and then no longer has access to all of the information that's usually readily available through the employer's internal websites or through their benefit vendors' websites. Once that access is lost, it's very hard to go back and get that evidence. Now, there are mechanisms through litigation and some of the administrative processes in which an employee can collect some of this evidence, but in any of those cases, we're really relying upon the employer being honest about disclosing whatever information is out there that the employee has requested or that the employee is entitled to request. An employer who has already done the wrong thing or has decided not to do the right thing for the employee may not be the party that we want to trust to be honest with us and provide damning evidence. Sometimes the employers do the right thing and produce the evidence, but there are certainly situations where the employers try to destroy or conceal or hide evidence that harms their position and helps the employee. So not having that evidence already in hand can be really harmful to the employee and can limit some of the opportunities. Additionally, having access to that information early on allows the employee, and especially an attorney, to assess the situation and craft a better solution and path for that employee going forward. Otherwise, the attorney is relying upon largely what the employee has said and what information might be publicly available or available from other friendly sources. Another reason why it's important is that if an attorney can present a strong case up front for the employee's claim, that's usually the best opportunity to get a good settlement early on, because that way the employer knows exactly what's coming their way. They can forecast their success or failure rate right up front and try to avoid wasting time or money defending against what is already clearly a good case. So that evidence can be very useful. Sometimes as well, when events occur that need to be referenced, and this is true often in harassment type claims, sometimes the employee's notes or copies of documents are the only evidence that exists or has ever existed regarding these important events. Many employers have policies where documents are destroyed on a routine basis, not because the employer has some nefarious strategy in mind, but because there's only so much paperwork that they can hold on to. And sometimes some paperwork doesn't need to be held on to for years. This is true for documents that relate to just the normal business for the employer. And even when there are legal requirements to retain documents, those requirements almost always come with a limitation on how much the employer needs to go back and withhold. So it may be the case the documents that the employee has copied now represents the only remaining evidence that something occurred or that some document was created. And of course, if we're talking about events that occurred, there's probably not going to be a paper trail other than whatever the employee creates. So from that standpoint, the employee's own records may be the best evidence that's going to exist. So with all of that in mind, let me point out 8 things that I think every employee should be doing right now, or should go out and try to collect from the employer's files and systems and protect themselves. And let me point out that for all of these documents that I'm going to discuss, that these records should be kept away from the employment site. They should be kept personally by the employee at their home or a safety deposit box or just anywhere that is under the employee's control and not under the employer's control. So here we go. Number 1, keep copies of pay stubs, timesheets, and your tax forms, specifically the W-2s or, if you're a contractor, your 1099 forms. These are going to be incredibly important if you have any kind of wage-based claim for overtime or minimum wage or tip violations. If you're a salaried employee even, having access to these documents can be useful if you've been improperly classified as a salaried employee or your employer just isn't making the payments that they're supposed to against your salary. Oftentimes, this information is available through the employer's internal site or through whatever their payroll processor is, that this information can be pulled and printed and saved somewhere else. It doesn't have to be printed. You can save electronic copies of it as long as the electronic copies come with the complete documents. Number 2, keep copies of benefit statements, benefit handbooks, and benefit descriptions. This can be a real issue if you have any kind of claim for especially retirement benefits, but for health benefits as well, to be able to go back and show what the benefits were at the time that the claim arose. In my time working with retirement plans before becoming an attorney, there were always people who were retiring or retired, and there was some problem from the employer side finding records of where they worked or what the particular plan formula was at the time that they worked in this particular division that was acquired by companies, and now they work for some massive Fortune 500 company. If the employee doesn't have those old benefit descriptions or benefit guides, it's very difficult to go back and look over 40 years of employment records to go fish out some document that a company that was acquired 4 times over had what their benefit formula was. This can also be a real problem because a lot of times the formula that the employer can find is usually a less beneficial formula. And that's because over time employers have cut back on their pension benefits, cut back on company match and 401ks, and other types of retirement plans. So it's important to keep those documents and keep records of them just in case something happens, because the last thing you want to do is be preparing for retirement and then have to go back and try to find all of this information in which you're probably not finding it, quite frankly. As an aside, if you've been divorced and your retirement benefit has been divided according to the divorce decree, you definitely need to keep all of the information about the division. But also you need that benefit information just in case the division was improperly done, to be able to go back and show what the plan formula was during the time of marriage, the way that it should have been divided. Number 3, keep copies of merit reviews, annual reviews, any other kind of review that's formal or informal that your employer goes through, as well as any kind of disciplinary documents if you've been written up or put on the ridiculous verbal written warning. Any kind of documents really that relate to your performance, both good and bad, keep those documents. It's pretty much a guarantee that your employer is going to keep those disciplinary documents, but sometimes those merit reviews or the other annual reviews that speak positively of you seem to disappear from files. Or if they're informal reviews, they may have been shot out as an email or, a memo that somebody typed up in a hurry, and there may not be copies of that memo anywhere else. The employer might not have saved the copy. They may have just changed the name on one basic memo and sent it out to a bunch of people, or the email may be just somewhere within a flood of emails between you and your boss. Hang on to those documents. The reason why, in particular, the merit documents are so important is because it's the best way to prove that you are performing when an employer argues that you are a poor performer or that you are being disciplined. And sometimes employers do go back and create disciplinary records. Supervisors will try to slip those into your file to show that you were actually a bad employee. But if there's a positive review and then suddenly a negative review in the file, or the other way around, if these are close in time, something's not real between those files. It's highly unusual that an employer goes from being ecstatic with an employee to suddenly being angry about their performance. It does happen, but it is suspicious in most cases. So hang on to those documents too. Number 4, keep any of your hiring or promotion documents. Anytime you're hired into the company, if you get an introductory letter or an offer letter, keep all that stuff. Any kind of onboarding paperwork, keep that. Same goes for a promotion. Usually, sometimes employers send out offer letters, or they'll send out letters explaining the terms of the promotion. Keep all of that stuff. It can be very helpful in explaining how you got into a job. If you get into a situation where you're disabled and the employer wants to argue that you're not capable of performing the job, that information, those documents may show specifically what the job was when you were hired at that time, and then you can go back and show how you're capable of performing the job based upon that description at the time that you were hired in. And along with that, one very important piece is, if you can find an advertisement online, especially if it's something that actually correlates to how you applied for the job, any kind of information that shows the job description at the time you were hired, save a copy of that. For the same purpose, you want to be able to show that at the time you were hired, these were the key functions that the employer identified in its own words, in its own way. And that can be very useful to combat some of these disability claims. Sometimes FMLA claims will fall into that as well. Number 5, keep those associate handbooks. These are the documents where the employer emails them out once a year, and they make you sign some acknowledgement and send it in, or send an acknowledgement email that you got it and read it, and you probably don't read it, you probably delete the email, and you never have a copy of this document. Save those handbooks. Each time they come out and there's a change, save the copy, save every version of it. These handbooks can be useful in showing the employer's normal practices. It can also show the existence or non-existence of a policy at a particular time. Now, employers are not bound by following their own policies in most cases, but when an employer deviates from its policies, there is a good reason to question why that deviation occurred. And that can be important for any kind of discrimination claim. Sometimes it's important for pay claims. If you're fired and your employer has a policy of paying out vacation time, and you were fired or you quit with a bunch of vacation time, having access to that policy can be important to go file a claim to get paid out that unused but accrued vacation time. So I know you probably don't read these handbooks, and you should read them, but definitely hang on to those copies and make sure you have a copy each time the policy changes. Number 6, create your own notes of any problematic activity that occurs in the workplace. If you feel like something bad is occurring, whether it's targeted at you or somebody else, you need to make notes, at very least for your own purpose, that explains who was involved, what happened, when it occurred, where it occurred, if you know why it happened, or how it came to be that occurred. This is especially important whenever harassment claims are brought about, because often your notes will be the only evidence that occurs other than people's testimony, which of course everybody who's involved in that situation is likely to tell a version of the facts that is beneficial to them personally. But if you have notes that you took down at that time or shortly afterwards that described what occurred, that can help boost your testimony and call into question other people's testimony. But this doesn't apply just to harassment or discrimination type claims. This can also be important when you have other problems, pay issues, benefit issues, FMLA leave issues. To be able to document the steps that you took, who you talked to, what you were told by that person, what action they said would occur or would not occur, what you asked them to do. This kind of information for the same purpose will help bolster your testimony to provide evidence that something did take place, and it will also help you recall what it was that occurred in the sequence of events, because, hey, look, most people don't remember all of this stuff down to the dates or times or, where things took place. So if you've got those notes, that can help you go back and say, you know what, yeah, I do remember this happening, and this happened on this date, and you can speak more specifically about what happened and the chain of events. It also makes it easier to go back and look for other evidence that might agree with your explanation of what's occurred. So if there was a discussion on a particular date about a pay issue, we know to go look for perhaps evidence such as emails or phone calls to the payroll vendor that may discuss those issues. And that may help us track down and narrow the focus of the evidence that we go chase after, which can help us find something that's useful, but can also help avoid unnecessarily wasting resources looking for something where it may not be. And number 7, keep any copies of emails or other documents that discuss positive comments about your work, negative comments about your work, or any kind of problems that have come up. And this kind of ties into pretty much what we've talked about with everything else, that these emails can be evidence that you were doing a good job when the employer says you weren't, that problems had arisen when the employer denies they existed, that you took certain steps to try to fix a problem that arose, or whatever the situation is that's given rise to a future claim down the road. Hang on to those emails, print them out. That's usually the best option when it comes to emails, because you want to be real careful about sending out employer emails to a private email account. If you're sending out a bunch of your emails to a private account out of your company account, sometimes employers can see that and start to get concerned about why these emails are going out and what kind of information you're sending out. So you don't necessarily need to expose yourself that way. If you print them out and just take them home, that's usually a little bit more covert and avoids creating an uncomfortable situation. When it comes to emails, there's so many emails that are sent on a daily basis from every individual. It's really hard to be able to go back and trace through all of those emails, trying to find specific emails that correlate to a particular claim that arises down the road. If you can pluck out a printed copy of the emails, we know where to go look to find copies of those emails on the employer server or their email backups, and identify that those emails do exist and the employer has copies of them as well. And last, number 8, this one is really not so much about documents to create or protect as much as it is about something you need to do, and then preserve documents or create notes that identify these acts. And that is, if you believe you're being harassed in the workplace, you need to make sure that you're following whatever the employer's anti-harassment policy is. If they tell you that you need to report this to a particular person in HR or management, make sure you are doing that and doing it right away, and then documenting that you've had those conversations. Sometimes it's easy to just send that person an email and explain whatever has gone on, and then print out the copy of the email. That provides pretty good proof, and that's a good way to do it if it complies with the employer's policy and if it's a reliable way for you to present that information to that individual. Not all employers have email systems that employees regularly access, or you may not work at a job where you're in front of a computer. If that's the case, do whatever the policy says and then write down some notes and identify what it is, what steps you took, and knock out who you talked to and when and where and how and all that good stuff. But that's really important, because with harassment, if there's a policy out there, in many cases you've got to prove that you tried to use that policy and for whatever reason it just didn't do its job and you continue to be harassed. So those are eight things. That's certainly not all that an employee should be doing right now or doing in the future. It's not specific to any kind of claim, and certainly for certain rights that employees have, there are other steps that need to be taken that are specific for those claims or to exercise those rights. But those are 8 core steps that really any employee should be taking right now, if they're not already, to protect themselves in the event that something terrible happens down the road. One thing I will say in closing about these 8 steps is that when you're taking documents from your employer, you need to be really careful about what documents are going out the door with you, because what you do not want to do is to take out confidential business materials with you. Even if you've never signed any kind of non-disclosure or confidentiality agreement with your employer, you still have a duty as an employee not to take trade secrets or any kind of confidential information like that that's integral to the employer's business and take it with you. It exposes you to a claim by your employer that you stole this information and did something bad with it. So don't do that. Really limit yourself to taking information that is specific to your role as an employee, and I mean like the associate handbooks that are specific to your employment events with the employer, your hiring, your promotion, any kind of non-disclosure agreements you signed, any non-competes, that kind of stuff, as well as documents that reference your compensation, your pay and benefits. Your notes, of course, are yours and really should not include anything confidential about, it shouldn't have client lists or customer phone numbers or anything like that. The real issue where this comes up is in emails. It's very easy to just sort of print out a whole email chain, but if part of that email chain has confidential information, you need to pull that out and not print it, or if it prints, destroy that portion. Don't take out anything that is confidential for the employer. If it has information about clients or the employer's particular processes that relate to something beyond their basic employment acts or their employment processes or policies, you should be very careful about taking that out, and when in doubt, leave that stuff behind. And of course, if you have any questions, talk to an employment attorney and let them advise you about what to take or what not to take. But that's pretty much it. I hope this video has been helpful. It's run a little longer than I thought it would, but these are all really useful documents to either create or to take with you and protect. Like I said, if you have any questions about what you should be doing in general or for a particular kind of right or claim you have, definitely talk to an employment attorney. So that's pretty much it. Thanks for listening. I hope this was helpful, and I'll see you next video.